Hello and welcome to the Husch Blackwell Labor Law Insider. I'm Tom Godar, your host, and I'm excited to share with you the developments in labor and employment law that we're seeing across the board, and particularly through the National Labor Relations Board and its General Counsel Abruzzo. When President Biden was elected, he said he was going to have the most employee and union-friendly administration ever, and he has fulfilled that pledge. I have HB colleagues and others who are thought leaders around the country taking a look at some of the issues challenging employers and giving them pause for consideration and maybe making some changes in their own workplace. So as we move forward on our Labor Law podcast, get ready, buckle in for a wild ride exploring the Labor Law Insider.
It is great to get together for one more Labor Law Insider, the first of the spring of 2024. And what a topsy-turvy time we've had since we began this podcast now, almost 3 years ago, Terry?
Pretty close.
Yeah, we had thought that when President Biden was elected and the National Labor Relations Board majority and the General Counsel for the National Labor Relations Board would change, that it would herald a lot of changes. And now we weren't unique in thinking that, but we certainly understood that our clients and our friends would see a lot of change. And we've talked about that without stop since that time. And it continues, but I thought we'd do something different today. And I think I have the perfect folks to help me do that. And that's take a look at some of the practical implications, the kind of calls that I get that my colleagues, Terry Potter and Mary Ann Zach, will introduce in a moment, get that our 50 or so colleagues are getting every day regarding issues related to time off, related to coming in and understanding how to conduct an investigation, discipline, all those things. Those are real world questions that are having new answers than they had just 2 or 3 years ago. And we want to talk through some of those real world questions and answers that are changing because of the way in which the National Labor Relations Board has changed. So welcome aboard, and welcome aboard for her rookie run as a labor law insider, Mary Ann Zach. Mary Ann, how are you?
I'm good. How are you?
Great. Mary Ann was practicing out of our Washington office and is an East Coast product. She went to Stony Brook in New York and graduated from Hofstra Law. But that's not where you started your life, is it, Mary Ann? Tell us a little bit about your background.
Yeah, so I have lived in Long Island, New York most of my life, but took about a 5-year detour in my early years from infancy to about 5 years old. I grew up in St. Thomas, the U.S. Virgin Islands. So limited memories, but I'm sure my parents had a great time in the Caribbean for that period of time.
I don't know how we got you back north, but it's great to have you. It's great to have you on board with Husch. It's really fun to get to know you and to see how you practice with so many of our clients. And we have a very seasoned member of our Labor Law Insider cast. That's Terry Potter. Terry's out of our St. Louis office and has every kind of accolade you could imagine, from best lawyers and on goes the list. But Terry, give us one sort of insight into the very special way in which you see the labor law world.
Well, there's no question the biggest change that's occurred since the Biden administration. In my 40 plus years of practice, I've never seen such a dramatic shift in favor of unions. I won't say in favor of employees. I will say in favor of unions, because that's the ultimate endpoint, is not helping out employees necessarily, but the board's definitely helping out unions.
Thank goodness we've talked about that on the Insider in terms of the number of elections, the number of successful elections. We just had an election in the South at an auto plant where the union won the first time in history. So on and on goes that union friendliness. But I wanted to take it slightly differently today, which is our non-union clients, as well as our union clients, in just day-to-day stuff, are making phone calls to me saying, "Hey, Tom, now what?" And I shake my head a little bit thinking, well, first, they haven't read our alerts. But secondly, until it really comes home, some of these changes aren't necessarily the kinds of things you live and die with, especially since so many of our clients have HR directors and officers and managers who are, let's be honest, overburdened, have a lot going on. And their job isn't, they seem to go and spend an hour a day refreshing as to what's new, but putting out the fire that presented itself that day, hiring the employee that they needed to fill that job or that post, looking at the remote location that they just brought on or that they're bringing down. But all of that has the implications of changes because of the board changes that Terry was just mentioning. So I got a call the other day. A client, longtime client, says, hey, Tom, we need some help with a discipline, maybe up to termination. This employee, well, we're so frustrated. First of all, the person was put on suspension after our investigation and told, you may not talk to anybody outside of me, that is the HR person, regarding this investigation. And immediately we got a report that they sent a text to one of our funding agencies and we're on the phone with another employee. Tom, can't we just let that person go? Isn't that all by itself enough of, basically, I'd call it insubordination. Folks, what do you think?
Yeah, I mean, this is so typical, Tom, of things that people who aren't familiar with the NLRB run into, and if they're not careful, can result in some litigation that they're not prepared to litigate. Unfortunately, in the scenario you described, it's very likely the board would protect this person in terms of having the conversation with the funding source and say that person was engaged in what's referred to as concerted protected activity, and therefore any discipline fostered against that employee would be unlawful.
Agreed with Terry's point. This is a frequent issue, and I think especially when it comes to, HR with our clients and the National Labor Relations Act, a lot of the time I hear, oh, well, our employees are not a union, are not in unions. I don't have to worry about that. And that's, a misconception. So first, just the understanding that the act applies to all employees, not just those in a union.
Good point.
And second, obviously our clients have an interest when it comes to investigations and trying to keep these things confidential to the extent there's always concern about intimidation or retaliation in the workplace. But to Terry's point, under current board law, there is a concern when there's a blanket request to keep things confidential. Certainly if we try to narrow that request and say, look, during the ongoing nature of the investigation, we could try to limit that confidentiality requirement, but just a broad statement that you cannot speak about this, yes, the board will likely find that unlawful. And even a narrowly tailored instruction to keep an investigation confidential during the pendency. The current GC, like Terry mentioned, how, this board is union friendly. The current GC has that type of confidentiality rule in her crosshairs. So it's something to be aware of that could even change down the road.
But, my client says, but we have it written right in our policies. They know that this is our policy. You must keep information in the context of an investigation confidential, as well as all other information confidential. Is that going to get you out of the woods?
No, unfortunately, it's not. In fact, the policy itself would probably be found unlawful too. The fact that you're even issuing that, because again, as noted earlier, it would be overly broad. The NLRB doesn't have a problem if you limit the scope of any limitation regarding conversations in the workplace to a particular time frame or a particular group of employees, something like that. But an overly broad keep your mouth shut rule just isn't going to cut it, and the NLRB is going to jump all over it.
Agree, Marianne?
Agree, 100%.
Well, not a problem, because remember, they brought this person in for discipline before they violated what we now might discover is an illegal policy in their handbook. So let's take a look at the handbooks, folks, shall we, and change those policies. But because they brought that person in, and in this case, the client said, well, the person was seen in the lunchroom recording a conversation that she was having with her supervisor. Now, the supervisor wasn't aware of it, and another person ratted her out. And that's really why she was being disciplined, because she was recording this conversation with the supervisor surreptitiously in the lunchroom. And again, our policies say you can't have audio or visual recordings in the workplace. Are we okay? Can we still move forward on our discipline?
Go ahead, Marianne, tell him the good news.
Recordings in the workplace, I think, are tricky. And when it comes to workplace rules in these types of situations, obviously everything's specific, but to Terry's point earlier, when you're looking at workplace policies and rules, the broader they are, the greater the chance they could be determined to run afoul of the act. So if we have a broad policy that just outright says, no recording in the workplace without any exceptions or any narrowing language, yeah, that's likely to be found unlawful because to the extent, an employee is recording in furtherance of their protected concerted activity. So if they think, the discipline being imposed on them is unfair, or if they're recording because they want to discuss wages and terms and conditions of employment with their manager, and then, incite group activity in doing so, that's likely protected. So when we discipline or say, look, you violated our policy, that's going to be found unlawful compared to recording policies that, are more narrowly tailored where they're prohibiting recording about, sensitive client or patient information, for example. That would be found likely to be okay. But just the general prohibition, that's definitely problematic.
So if I share with you that in this scenario that I'm looking at, although it has all sorts of real life call applications over the past couple of months, that this was a setting where there were third parties who were receiving care in this setting. And so the policy says there's no recordings allowed here because they may inhibit communications with our clients or our residents or patients, or fill in whatever word you like there, and or might be a violation of our clients, our residents, our patients' privacy rights. Does that make the discipline based on a conversation just between a supervisor and an employee okay because the policy itself is okay?
Well, I think the big issue you always have in a healthcare setting is a concern regarding HIPAA. And that is a difficult burden even before the NLRB to establish that HIPAA violations are sufficient to provide discipline for potentially disclosing protected information under HIPAA. There is an extensive GC memo on this whole topic, which from my standpoint pretty much talks in circles regarding whether or not this sort of scenario should result in a finding of a violation. HIPAA isn't going to totally protect you. It's a factor to be looked at, but you've got to look at all the facts and circumstances in the situation. And that's the problem, especially in highly regulated industries like healthcare. You have multiple regulatory bodies controlling the workplace. And here you've got potentially, a HIPAA regulation coming in conflict with the National Labor Relations Act. And, how do you resolve those differences? It's difficult.
And Terry or Marianne, what happens if it's not HIPAA? That's patient. And so there's a specific definition of what a patient is. There's a specific definition of healthcare information. But let's say that you're taking care of the developmentally disabled, but you're not doing it in a clinical setting. This is just a residential setting. Can you potentially expand that still narrow definition? Or each time you expand it, do you just sort of take on another degree of potential risk by saying, well, you shouldn't be recording that kind of thing because it's potentially a chilling of the employee's exercise of their rights under stereotype? Anyone want to jump in?
Yeah, I think it's analogous to a patient situation. And even the argument can be made, even if you're outside a clinical care setting or developmentally disabled setting, even when it comes to confidential, like customer or vendor information or corporate trade secrets, all of that can be, rules can be tailored to prevent the disclosure of that type of information. I think it comes down to, can the employer, can the client articulate a legitimate business reason for the narrowing and maintenance of that type of workplace rule. Now, the rule itself may be lawful, but the application of it, could potentially be unlawful. For example, if the recorded conversation was not occurring in a place where, patient or client care was happening, I think that could be a distinction the board will look at, and they may say, well, the rule itself may be defensible, but how the employer applied it could it be violative of the law? Certainly. But I think, when it comes to narrowly tailoring those rules and making them prohibiting recording when it comes to sensitive information, I think clients are in a better position to defend themselves versus just, like we already discussed, a broad workplace rule.
Yeah, but the shame of it all is you have to be a labor attorney to understand all of this. And who in the world, in the way of our clients, is going to have a full-time labor attorney involved in every conversation in the workplace so this doesn't happen? I mean, the nuances are just all over the place. It's not fair for employers to have to deal with this sort of micromanagement to the point where it's difficult for them to run their business and to protect their rights and their customers, or in this case, patients' rights. And that's when I get upset about this situation.
There's complexity at every level. I appreciate you putting it in that sort of lovely context area that we're expecting an awful lot of folks who are trying to keep their day-to-day operations moving, even with, the 100 or so labor and employment attorneys that we have at Husch Blackwell sitting on phone calls like this one for an hour, trying to nuance our way through these changes. And even we have, interpretations that we're not all squared up because it is so complex. In that complexity, what happens if the scenario includes the fact that the client says, oh, by the way, this person is a group home manager, and therefore they set the schedules for the rest of the staff that's there. They don't hire the staff because that's done by HR and by the regional director, but they do have the capacity to, if somebody's absent or somebody's really mucking up, to recommend discipline. Is there a possibility that this person's going to be out of the long arm of the NLRB law?
Yeah, I mean, I think that fact pattern is, welcome news to a labor attorney, because under the Act, what's called 211 statutory supervisor, they're not protected by the National Labor Relations Act. So some of the factors you just mentioned, like scheduling, recommending discipline, using independent discretion to do so, that individual could very likely be determined to be a supervisor, and then they fall outside the protections of the Act. So then all the activity that they engage in, we could take, discipline and take action that wouldn't be violative of the law, because ultimately when you're a statutory supervisor, you're acting on behalf of the employer. You're the employer's agent, and you're supposed to be acting in the employer's best interest. The test for 211 supervisory status is very specific and fact intensive. So, when we get posed with those facts by clients, we kind of dive in and take the inquiry step by step. But certainly, I think you presented an arguable fact pattern where we could make that determination.
Mary Ann, that was terrific. And audience, we're going to pause right there because the conversation continues with some really practical scenarios and some advice that Terry and Mary Ann share. And it's wonderful stuff, but we want to be able to take a break and be back at you in a week or two as we continue this discussion. And I thank you so much for following along with me as we've got a little bit of, as you know, an audio glitch here with a different kind of microphone than we'd normally use. But thanks for hanging with us in another week or two. Join us for part 2 of this very practical approach to what does it mean with all of the changes in labor law, both for our union clients and friends, but particularly for those of you who are working in the non-union world. Thanks again for joining us at the Labor Law Insider, and we'll be talking to you in just a couple of weeks.